what the chapter method does in a trial to the court is magic. Think about the problems of a judge writing findings of fact and conclusions of law. The chapter method organized the judge's findings of fact. They are literally being written out. Our leading questions to a hostile witness is finding a fact, finding a fact. It's admission, admission, admission. And there's nothing more pleasing to a judge than the work being done for them so they don't have to reorganize their notes. And this magic phrase, even the prosecution witness admitted, or it was the prosecution witness who conceded that. It's so much easier to find reasonable doubt when we're not calling on a judge or a jury to believe our version of events as told through our witnesses, where we're only asking them, listen, it's not me making this up. The prosecution witness told you this answer. The snitch. We are going to cross the snitch. And one of the things we may be doing is saying, we're suspicious of your story. Isn't it great? You needed a story to get out of going to prison and you got one just at the right time. And so we do a chapter showing the chronology. There's a crime, your co-defendants get arrested and you're arrested, and there's a preliminary hearing and you're bound over for trial, and trial is set for October 11th, 2006. And on the Friday before trial, your lawyer filed a motion that says, we don't want to go to trial. Would you give us some more time? And the judge says, no, we're going to trial Monday. That happened on Friday. You went back to jail, and within an hour, you're calling the district attorney saying, your roommate, your cellmate has confessed to you, and if they'll just give you a deal, you'll talk about the confession. And what happened on Monday? You don't go to trial on the robbery you committed. You're not going to prison. What happens is the DA moves to continue the case because you're cooperating. Something that shows a story of what the prosecutor gave to get the cooperation is the kind of chapter we're going to use repeatedly. Let's do another one. Here's a chapter bundle. Your client is a freshman at the Air Force Academy. He is on the football team. It's spring break. He throws a party at his house. His parents aren't home. His high school friends come to the party. One of his friends gets dead drunk. Your client tries to keep his friend from driving home, but the friend insists, and your client tries everything reasonable. And when reason doesn't work, your client hits him one time. The friend falls over, hits his head on the pavement, and is knocked out. Your client and his friends at the party take the friend in and lay him on the couch. He is unconscious. At certain times he wakes up and talks, but he's incoherent. At certain times he is vomiting. John says, I think he has a concussion. And because your client plays football, he knows what a concussion is. But your client thinks that it's just a drunk sleeping it off. And he does not alert anyone. And in the morning, they take the alleged victim home. They take him to his parents' house. They don't tell about his hitting his head. The parents become worried when their child doesn't wake up. They take him to the hospital. He has a closed head injury, a subdural hematoma, and he's going to die from it. And your client's going to get prosecuted. Not for the punch, because the punch is going to be excusable. A jury isn't going to convict over stopping somebody from driving drunk. The prosecution theory is it's criminally negligent homicide. You should have realized that he had a closed head injury and needed treatment. What is the defense? If we call our client Why are we calling our client? We're calling our client because our client's going to say, I didn't think he had a closed head injury. I thought he was drunk, sleeping it off. And your client's going to say, every one of the symptoms we saw became incoherent, vomiting, thought he had a concussion, sleeping it off. Every one of these, your client says, I thought he was just really drunk. Now, why cause a client to say that? What is there in the client's story that we could get a prosecution witness to say for us? Let me give you minimum discovery. You are going to have a great deal more than this, but let me just show you how we milk the discovery and make the witnesses into our witnesses. The parents took the deceased to the emergency room at midnight. He is seen in the emergency room by a doctor, a competent, qualified emergency room doctor. That doctor gave some brief tests, and then by 12:30 that night had picked up a phone and called a neurosurgeon, an expert in closed head injuries. The neurosurgeon woke up, came immediately to the hospital, and began tests and treatment. What can we do with these things? Instead of saying to ourselves, I'm going to tell my story through my client that he just thought this was a friend who was really drunk and was sleeping it off, couldn't we get the emergency room doctor to talk about how in his vast experience he has seen a great many drunks, that there is such a thing as alcohol poisoning, that in fact we tell fraternities at colleges now, you have immunity. If your friend is drunk and passed out, call us, bring them in. Why? Because there can be so much liquor in a person's body that their body is shutting down, that becoming incoherent is consistent with being drunk, that vomiting is consistent with being drunk, that being out of it is consistent. In other words, how many parts of our client's story can't we get the emergency room doctor to do for us? And look at how we do it. The setup isn't an angry, aggressive cross. It is not, and let's talk about how my client is just a college student. It's the opposite. It's let's make you, doctor, into a great ER doctor. Let's talk about all of your wonderful training. Let's talk about your experience seeing drunks. Let's put you in your comfort zone and do chapters on alcohol poisoning and drinking too much and becoming unconscious. And now let's do all of the training you had and how you put that training to use, doing diagnostic tests to see if there's a closed head injury. And even though you're a great doctor with tremendous training, what you did at 12:30 at night is say, I need an even more trained doctor. That's why you called Dr. So-and-so. You woke her up in the middle of the night because you needed an experienced neurosurgeon. Now, what are we going to do with the neurosurgeon? We're going to take the neurosurgeon and we're going to build them up. Our chapters are not attacking. Our chapters of you're great, you're well-trained, you're extraordinarily experienced, and it didn't trouble you to get a call at 12:30 at night from another doctor. You didn't say, well, you're a doctor, you take care of it. There are some injuries that are so hard to diagnose. There are some kinds of closed head injuries so hard to understand. It made perfect sense that somebody of your sophistication and training should be called in. And when you got there, you did all these tests. Where is this going? We're proving our client's version. I didn't understand it, by making the prosecution witnesses even brighter, by showing how well trained they are, by having them talk about you can mistake being drunk for a closed head injury. And now we're not having to call our client. And since we're not having to call our client, we're getting out of questions to our client. And one of the questions is, you've had concussions, but we're getting out of a host of questions that aren't going to be asked to our client. We are proving our case through their witnesses because the jury is saying, wait a minute, all of you experts know all of these tests. You're thinking a college freshman should have had that degree of sophistication? Let's take a look at prior inconsistent statements. Because the method, the problem we have with prior inconsistent statements is one of two problems. Either we are trying to show a jury that the earlier version is to be believed over the later version, because really, if we like the newest version, why would we impeach? Wouldn't we stick with it? We're trying to invest importance, believability in the earlier version. Or another problem we're trying to solve with these chapters is you've given multiple versions and you're a liar. We can't believe you on any of your versions. Now that's different. The credibility you've changed your story cross is not nearly as assaultive. It's not nearly as cutting. It simply says, I'm going to make you into a great witness on your first version, because if a jury believes your first version, then your new version that says, and that's the guy who robbed me, they're not going to believe. But on the snitch, where we're saying don't believe any version, what we're doing is we're saying every version you give sounds like the truth because you make it sound like the truth. Here's that second one. We have a snitch. He has inconsistent versions. He says he's an adult male, and he says he watched his father kill someone. And our theory is, no, your father didn't kill anybody. You did. So the snitch's first version was he saw his father hit Burt Daniels in the head with a, that's his today's story to the jury. I saw my dad do this. Now, if that's completely believable, let's let it be believable for a moment. Let's show how today's version is. There's no question. You saw your dad do this. You're looking straight at him. You watched him pick up the hammer. You watched him. You say to me, why on earth am I doing this? This story is terrible. Yeah, but if this story is the truth, then it always should have been the story. Well, now that you've told the jury that you saw this, that you saw it clearly, that there's no mistake, let's look at your first statement. January 22nd, your statement. You were asked, how many times did he get hit? And your answer, I don't know. I heard once. I just kind of closed my mind. And the cops asked you, well, did you actually see the hammer strike the victim? And you said, no, I didn't. I know he hit him in the head, but I didn't see it. But that isn't the only time you've told this story. Then the district attorney sent their investigator to interview you. And the investigator, we're going to set this up. We're going to, how important it was and how this is the investigator and he's trying to get to the bottom of it and you're going to help him see a little story. We don't want to make this go too quickly. We got to milk it. We've got to make every story equally important, equally plausible, because if multiple versions are equally plausible, then a jury can't figure which one to believe. Now that's different than the prior inconsistent statement of the eyewitness, where we're saying the first version is completely plausible, which is why you shouldn't believe the second one. It's not that she's lying to you. It's just She's changed her story to fit the description of my client.